to technical difficulties this morning, so just hang tight. We'll start in about 5 minutes here.
Do I want to join with computer?
Join yes, but turn off your.
Oh shit, my coffee. Yeah, of course. Shit, I forgot my phone again. God damn it. Where the hell's my phone?
Good morning, Commissioner Cardenas. We're going to go ahead and get started this morning. It's February 3rd, 2021. This is our FPPC Law and Policy Committee meeting. Ms. Linker, would you please call the roll?
Commissioner Cardenas,
I am mostly here.
Chair Matich.
Here. All right, we'll proceed to item number 1. This is public comment for items not on the agenda. Do we have any public comment on the telephone or digitally for items not on today's agenda? Hearing and seeing none, we'll proceed to item number 2, approval of the January 13th, 2021 LNP committee meeting minutes. Commissioner Cardenas, did you have any edits or comments on our meeting minutes from January?
I do not, Mr. Chair.
Would you care to make a motion to approve?
Yes, so moved, Chair.
And I will second. Ms. Linker?
Commissioner Cardenas,
Yes.
Chair Matich.
Yes.
The motion passes.
Proceed to item number 3 now. This is our legislative update. We have our legislative counsel, Ms. Nakano, to present to us this morning. Good morning.
Good morning,
Ms.
Chair
Nakano.
Matich. Good morning, Commissioner Cardenas. The main focus of today's legislative update will be to discuss additional details and development to the Commission's legislative proposals, but I have a few updates on other matters first. Staff has submitted draft language requests to the Office of Legislative Counsel, and we are continuing to approach potential authors and interested parties. Staff met with Common Cause to go over our legislative proposals, and their initial reactions were positive. We'll be reaching out to them again in the near future to go over the proposals in more detail and to get their feedback and hopefully their support. I also have a committee membership update. Assemblywoman Blanca Rubio will replace now Secretary of State Shirley Weber on the Assembly Elections Committee. Last week, a new PRA-related bill was introduced. It is AB 319, introduced by Assemblywoman Valladares. The bill has two main components. The first relates to legal defense funds. Currently, the legal defense funds of candidates for elective office or elected officers are exempt from contribution limits under the Act. AB 319 would extend the Act's contribution limits to those legal defense funds. The second component relates to contributions and expenditures from foreign governments or principals. Existing law currently prohibits foreign governments or principals from making contributions, expenditures, or independent expenditures in connection with a state or local ballot measure. AB 319 would extend this prohibition to the contributions, expenditures, or independent expenditures in connection with the election of a state or local candidate. And on to the Commission's legislative proposal update. I'll be following the staff memo attached to the agenda. It was helpful for me to conceptualize the proposals into three categories, which are proposals relating to enforcement of the Act, proposals relating to increasing transparency, and proposals for modernization, efficiency, and consistency. The first proposal would give FPPC special investigators additional authority to, among other things, access state and law enforcement databases and carry official identification. This would be the same level of authority that's currently granted to other state agency investigators, including those with the Public Utilities Commission, the State Board of Equalization, and the Department of Insurance. The second proposal would authorize the Commission to access tax records of public officials under investigation. It would accomplish this by requiring the Franchise Tax Board to permit a designee of the Commission to inspect those tax records. If information in the tax records is material to a specific matter under investigation based on a finding of the Commission's executive director, that inspection would be permitted. The proposal would require the Commission to notify public officials when their tax records are being requested and would require the Commission to reimburse FTB for the costs of providing this information. The Enforcement Division has estimated that it would make approximately 6 requests per year for tax records under this proposal. The third proposal would provide for increased penalties for a person who uses campaign funds in a manner that violates the Act and results in an egregious personal benefit. And we're defining egregious personal benefit for purposes of this provision to mean a direct personal benefit with a value of $10,000 or more to a candidate, elected officer, or any individual with authority to approve the expenditure of campaign funds held by a committee. The increased penalty we're proposing is up to 3 times the amount of the unlawful expenditure. And under this proposal, I included a couple examples to illustrate how this would work. So for example, if a candidate for elected office purchased a new vehicle for $50,000 using campaign funds and put the title of the vehicle in their own name instead of in the committee's name, they would be in violation of the Act. And because the vehicle was purchased for more than $10,000, this would be considered an egregious personal benefit, and the candidate would be liable for up to $150,000. And note that under existing law, the maximum penalty would be $5,000. The next category of proposals are those relating to increasing transparency. This fourth proposal relates to increasing disclosure for limited liability companies, and it reflects our best thoughts for how to approach this issue. Currently, an LLC can make campaign contributions or independent expenditures solely in the name of the LLC without disclosing any information about or providing a way to determine the source of the funds expended by the LLC. Under existing law, if an LLC qualifies as an independent expenditure committee or a major donor committee, it's required to complete a Form 461, which provides a summary of all contributions and expenditures made, as well as information regarding the filer, the responsible officer, and business interests. However, even with the recent regulation defining responsible officer, this reporting does not get to the true source of funds. In looking into options for this proposal, we did look at the New York law. Our proposal is similar in some ways and tracks the general concept of the New York law, but it does have several differences. Under our proposal, LLCs would be required to file a statement of members with the Secretary of State's office when an LLC qualifies as a committee or as a committee sponsor under the Act. The LLC would be required to identify members that fall into, excuse me, at least one of two categories. Those who have a 10% or greater membership interest in the LLC, and those who made a cumulative capital contribution of $1,000 or more to the LLC after it qualified as a committee or committee sponsor, or within the previous 2 calendar years before qualification. If a member is another LLC, they would be required to disclose the members of that LLC as well. The statement would be required to include certain information, specifically the name of the LLC and contact information for its principal officer or responsible officer, the name of each member who fits into either of the 2 categories I mentioned, the dollar amount of the cumulative capital contributions made by each member, the date of each capital contribution, and the percentage ownership interest in the LLC of each member. The New York law, by contrast, requires disclosure of the names of all owners and their percentage ownership interest, but nothing else about the owners or their contributions. Filing would be required within 10 days of qualifying as a committee or committee sponsor, or within 24 hours if there's an election within 30 days and other specified conditions are met. By contrast, the New York law requires a static annual fee or annual filing on December 31st. Under this proposal, if after filing its statement of members, an LLC receives a capital contribution of $1,000 or more, the LLC would be required to file an amended statement, which would require disclosure of the source of those funds. We've included a couple examples to illustrate how this proposal would work, a real-life example and a generalized example. For the first example, in 2016, LHR Investment Group LLC gave $3.8 million to a local ballot measure. The LLC filed a Form 461 major donor report, but as I mentioned before, that report does not require disclosure of the source of funds. Under this proposal, once the LLC qualifies as a committee or committee sponsor, it would be required to submit its statement of members, which would include, among other information, the name of the LLC's members, the cumulative capital contributions, and the date of each contribution. In the second example, a business person creates a LLC 3 years ago and fully funds it. 3 years later, the LLC makes a large contribution to a ballot measure committee. Under this proposal, even though the LLC was funded more than 2 years before qualifying, since the business person counted for 100% of the LLC's assets, that person would be listed on the statement of members. So I'll break here if there's any questions or comments or any feedback from the chair commissioner.
Commissioner Cardenas, any questions or comments for Ms. Nakano at this point?
No, I'm too excited by what I'm seeing and hearing to offer any comments at the moment, Mr. Chair.
Great. Thank you, Commissioner Cardenas. Ms. Nakano, just following up on example number 2 on the LLC bill. So this is a situation where the LLC was fully funded more than 2 years before the contribution was made. And the last sentence in your example Under this proposal, we would at least have disclosure of the person who made that contribution to the LLC, the capital contribution to the LLC. Does that include the date of that capital contribution as well, not just their name? So in other words, folks could trace that inflow of money to the LLC all the way back?
Yes, I think that even if it was more than 2 years, it would include the date of each capital contribution of each member.
Great. Thank you. I appreciate the clarification. Go ahead and continue.
Okay. The fifth proposal would transfer the duty to conduct lobbyist audits from the FTB to the Commission. This proposal would also add to the information required to be reported, including the names of those lobbied, interests lobbied, and the payments received for lobbying for the purpose of increasing transparency around lobbying activity. Currently, lobbyist reports are required quarterly. This proposal would also require monthly reporting in the third calendar quarter of each year. Quarterly reporting would remain for the other 3 quarters, and this more frequent reporting in the third quarter would allow the public to see what interests have been lobbied before final voting occurs in most legislation. The sixth proposal would extend the one bank account rule, such that all committees would be required to deposit all contributions into and make all expenditures from a single designated bank account. Currently, only candidate committees are subject to this rule. Extending this requirement to all committees would improve the ability of the Commission and committees themselves to track contributions and expenditures to increase transparency and compliance. The seventh proposal would transfer the duty to collect the penalty for failure to pay the annual committee fee and the original unpaid fee from the Commission to the Secretary of State. The Secretary of State is required to charge and collect the original $50 fee, and the Commission is currently responsible for collecting the $150 penalty and the $50 fee if a committee fails to timely pay the fee. Since this collection requires only an administrative collection process, we think that all of the collection of this fee, including late fees and penalties, can be consolidated with the SOS. The eighth proposal does 2 things. It requires statements of economic interests filed by a public official and for which the Commission is the filing officer to be filed using the Commission's electronic filing system. This proposal would also cap the gift limit at $500 and eliminate the biennial cost of living adjustment. The e-filing component is mainly for purposes of modernization, and it also increases efficiency for FPPC staff that processes these statements. The gift limit component is proposed mostly to create consistency. Because the gift limit is now higher than the income disclosure threshold, which is $500, this could create a situation where, for example, earned income of $510 would create a conflict of interest, but a gift of $510 would not create a conflict of interest. And I included an example that illustrates how the current limit creates inconsistency. The ninth proposal, which would generally require behested payment reports to be filed electronically, is also for purposes of modernization of the Act and efficiency. The proposal would require an elected state officer or member of the PUC to file directly with the Commission instead of with their agency, using the Commission's electronic filing system within 30 days of the behested payment. It would also require non-state elected officers to file directly with their filing officer instead of with their agency within 30 days of the behested payment. The proposal would authorize a filing officer to require electronic filing for non-state elected officers and would provide that an electronically filed report is an original report. And finally, the 10th and last proposal would remove gendered terms from the Act, consistent with Assembly Concurrent Resolution from 260 in 2018, which resolved that legislation, regulations, and other agency materials should remove and avoid the use of gendered terms. And if there's any questions, I'd be happy to take them.
Thank you, Ms. Nakano. Commissioner Cardenas, did you have any questions or comments for Ms. Nakano?
I do, Mr. Chair. Thanks. Thanks for the opportunity. From the outset, let me suggest, Ms. Nakano, in my opinion, referring specifically to the to our 2021 legislative priorities document that you were just leading us through. It strikes me as a matter of first impression as being a truly superlative piece of work. Just at the outset, in terms of ease of eating and of reading and comprehension, just outlining it this way and breaking it down into the three general categories as you have, just at the outset, it makes it so much easier for my tired little brain to come to grips with the sweep, but also the detail and the nuance that's often involved in legislation or proposed legislation. By the by, we know that in the Western tradition, we can thank my dear friend Aristotle from my youth as being the one to first suggest to us that to categorize things is an important first step to any serious inquiry. Starting with the first legislative proposal, Ms. Nakano, I believe I recall the answer to this when we dealt with it in the last calendar year. But with respect to the first two in particular, and I guess with respect to perhaps most or all of these, and our enforcement division has in fact had substantial engagement, maybe even ownership of much of what is here.
I believe that the original proposals originated from the enforcement division and were developed in consultation with them to make sure that it addressed their issues and was informed by their experiences.
That's right. Thanks for the reminder. Many of these proposals germinate up from within their respective division through the call for proposals process, if you will, that I recall now we have within the organization. Some, but not all of these individual proposals, Ms. Nakano, relate to a particular, or maybe more than one, but at least one existing piece of legislation, right? Is that not the case? Many of these would be amendments to existing legislation, is yet another way to put it. Is that correct?
Since we're in a new legislative cycle that started this in January, some of these proposals were introduced in previous sessions bills, but since we're in a new session, we'd have to introduce these as new bills. To my knowledge, the only one that is currently related is our LLC proposal, which is similar to Assemblymember Berman's proposal. But all of the others, we would have to find new vehicles for this session.
Yes, thank you. Many of these proposals would amend a pre-existing law, right? Like the behested payments, wouldn't that be an amendment to, right?
I see what you mean.
Yeah.
I'm sorry, I misunderstood. But yes, you're correct. A lot of these proposals, if not most of them, would be amendments to existing law as opposed to adding new sections or new sections to code.
And that reminds me of a question I had some time ago, again, relating particularly to the behested payment proposal that you have before us. When I questioned the application to the Public Utilities Commission of the state, and the answer was, well, that's in the original law. The wisdom to include the PUC, the infinite wisdom, I might add, has already been applied to the question. So any concern I have is above my pay grade. Now to LLC, and I appreciate the chair's indulgence. Now to the LLC specific campaign activity disclosure. I have no questions with respect to any of the particular details. I might add that throughout your document, Ms. Nakano, your provision of background and examples is truly helpful to me. I have found it truly helpful to be able to understand both the objective but also the context, right? The context within which the concern arises that compels us toward a particular legislative objective represented by your legislative proposal summary, which precedes both the background and the example. The only thing, Mr. Chair, I wanted to suggest in connection with the LLC legislative proposal here is I think last month I opined or perhaps more accurately whined that I might be open in the future, to the extent I have one on our beloved commission after this month, that commissioners join me in considering an actual ban above a certain dollar level of contributions made by LLCs, as is the case with the New York legislation. Any interest that I ever had in seriously contemplating that kind of a restriction on a particular type of organization's exercise of free speech has really waned by looking at this legislative proposal. There's something about having not the actual bill language, but what we have before us, which is the summary of the legislative proposal, our legislative proposal, its objectives, and a couple of examples of how it would play out, and how this added and unprecedented in the context of LLCs a measure of required disclosure would really add something to this commission's ability to ensure transparency, particularly in that area which at least since Citizens United has tended to be the darkest area of all of the activity that's under our purview. It's called dark money for a reason. But I am seeing this before me, Mr. Chair. I am sufficiently confident that were the legislature to see fit with this approach and adopt it into law, that this would be a terrific first step, and perhaps disclosure of this sort will be sufficient to shine enough light on that dark area of political activity to at least give people tremendous cause to concern when they seek to obfuscate, hide themselves from the glaring view of a polity that is tremendously interested in who the hell is doing what to whom and why. And so with that, I'll conclude my remarks. This is another terrific piece, in my estimation, of staff work. And I just feel real lucky to be even tangentially associated with it. Thank you, Ms. Nakano. Thanks, Mr. Chair.
All right. Thanks, Commissioner Cardenas. I would just echo, particularly on the LLC bill, I will tell you staff has spent a significant amount of time researching this issue. Ms. Nakano, Mr. Bainbridge, and others have really, I'd say, put in a lot of work on this. And to my mind, at least, the proposal that we have does strike a very good balance between allowing folks to continue exercising their First Amendment rights in a productive way, but then also ensuring the type of transparency the public needs in order to hold folks accountable for their speech and their election-related activities. So I do look forward to being able to present this to our colleagues on the commission, Commissioner Cardenas, and get their support behind this as well.
Indeed.
All right, Ms. Nakano, anything further you wanted to bring to our attention on the legislative update?
Nope, I have nothing further.
All right, thank you. I will call for any public comment on item number 3. Do you have any public comment on the legislative update? Hearing and seeing none. Thank you, Ms. Nakano. Appreciate it again, all of your hard work on this.
Thank you.
So our final item today is items for our March 2021 committee meeting. I think at this point, I would anticipate we continue to have a legislative update from Ms. Nakano to apprise us on her progress with regard to those legislative proposals we just discussed. Commissioner Cardenas, did you have anything else that you wish to have L&P take up in March?
No, am I on? Yeah, no, Mr. Chair, I think just our regular update, but I'm sure the committee at that time would be particularly interested in any progress, any authors of our proposed legislation that have come to fruition. The March committee meeting, I think, will be a very important development for us. Thank you.
All right, thank you. All right, do we have a motion to adjourn then?
So quickly? We hardly need it.
Unless you have something else, Commissioner Cardenas.
Not for the public record. No, thank you.
All right.
Yes, I hereby move that we adjourn, Mr. Chair.
Right, and I will second that motion, Ms. Linker.
Commissioner Cardenas?
Yes.
Chair Matich?
Yes.
The motion passes.
All right. Thank you, Commissioner Cardenas. Always a pleasure, and we'll be seeing you soon.
Yep.
Take care, sir.
Stay safe, everybody.
Take care, everybody.